The committee will come to order. We are pleased to have an extremely distinguished panel. I will introduce you from my left to right, your right to left. First, we have the Honorable C. Boyden Gray, currently heads the firm of Boyden Gray and Associates here in the district. Mr. Gray served as White House counsel during President George H.W. Bush's administration as an ambassador to the European Union during President George W. Bush's administration. Mr. Andrew Pincus is a partner at Mayer Brown, who advises clients on a host of financial services issues and is testifying today on behalf of the United States Chamber of Commerce. Mr. Michael Gerhardt is the Samuel Ash Distinguished Professor in Constitutional Law and Director for the Center for Law and Government at the University of North Carolina School of Law. Mr. David Rivkin is a partner at Baker, Hostetler, and co-chairs the firm's appellate practice. He served at the Justice Department and the White House Counsel's Office during the Reagan and George H.W. Bush administrations. Mr. Mark Carter is a partner at Dinsmore, where he advises clients on traditional labor and employment law. Mr. Carter has extensive experience litigating before the National Labor Relations Board. Pursuant to committee rules, all witnesses except members of Congress will be sworn in before they testify, so I would ask you to please rise and lift your right hands. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? May the record reflect all witnesses answered in the affirmative. We are pleased to recognize you for your opening statements. Sure all of you perhaps have done this before. The lights mean what they traditionally mean in life. And with that, we would recognize Ambassador Gray.
Mr. Chairman, thank you very much for the opportunity to testify. You've just heard an extraordinary tutorial, in a way, from Senator Lee covering almost every aspect of this issue, both constitutional and practical. So I'm going to try to keep what I say at an absolute minimum, since there's very little I can add. Just want to start with the point that as far as the CFPB is concerned, there are many who think it's quite unconstitutional with the lack of oversight. So the recess comes in without a confirmation process, or bypassing or ignoring the confirmation process, and provides even less oversight. As a practical matter, what has happened here and what will happen, if you look at footnote 13 of the OLC opinion, is that what the White House has done is to basically establish the basis for eliminating any need to comply with the confirmation process. What we have here was, as has been discussed in Senator Lee's testimony, not a delay, not an action, not the Senate lollygagging, but a situation where one nominee was in fact considered and addressed by the Senate and rejected, albeit by a filibuster to be sure, but the reasoning doesn't indicate any different, if anything different would have happened if he had been defeated on an up or down vote. The other two nominees, as has been discussed, were barely there. I don't even think they'd filled out their forms. They hadn't had hearings. So this wasn't a case of delay. It was just avoiding the constitutional process. Footnote 13 says there's no minimum time, and so it could happen over a Sunday. I want to just say a couple of points about what this means for the business community. I don't want to take any thunder or even downplay what the others are going to testify here, especially Andy Pincus coming after me, representing the chamber. But there's a lot of uncertainty. The President has given no guidance as to when he will do this, which agencies he's going to pick, what the reason will be. He said nothing about that. And so all agencies are under some, that have openings, are under some uncertainty. We don't know the litigation impact of what will occur. The OLC opinion, as has been observed, mentions that there are litigation risks. I don't recall a single instance when I was White House counsel where we commissioned and asked for an OLC opinion that came out saying this is a litigation risk. I don't recall that ever happening. That's a real red flag, but it certainly does set into a high uncertainty anything that these agencies do with these appointees. Regulatory uncertainty is a real problem. We don't talk about it that much, but in my experience, in the business community, representing the clients in the business community, having been a businessman myself, there's nothing more damaging than uncertainty, not knowing what the rules of the road are going to be. And for people subject to the NLRB with very, very broad jurisdiction, people subject to the Consumer Protection Bureau, extraordinarily broad jurisdiction with no accountability by the political branches, no accountability by the White House. We've been over no accountability by the Congress, and no accountability really by the courts, which are required to defer to the rulings of the Consumer Bureau. There's going to be amazing uncertainty that results from what has happened here. It just is unprecedented in my view. I want to just close by making a couple of personal remarks. I, of course, watched over this as White House counsel, as any White House counsel would and does. But I was also on the receiving end as an appointee in Bush 43. I was recessed at a legitimate 3-week recess. Because of Senator Reid, I was not re-recessed because President Bush thought that it couldn't happen. At the time, I was frustrated by it. They made me instead a special envoy. I want you to know that I was a special envoy. But I never felt, as frustrated as I was, that anything unconstitutional was being done by Senator Reid. I have a lot of other objections to how he tried to block me, but not the actions he took in the Senate. Thank you very much.
Mr. Pincus.
Mr. Chairman, Ranking Member Cummings, thank you for the opportunity to testify today on behalf of the U.S. Chamber of Commerce and the hundreds of thousands of businesses that the Chamber represents. The Chamber strongly supports the goal of enhancing consumer protection, but we're extremely concerned that the recess appointment is actually going to have the opposite effect, reducing consumer protection, creating confusion and uncertainty for businesses that want to comply with the law, and imposing unnecessary and duplicative costs on legitimate businesses. Rather than focusing on the constitutional issues, which I agree with Ambassador Gray have been well discussed, I'd like to focus on these consequences for consumers, for businesses, and for the economy of a judicial determination that the appointment of the director violates the Constitution. And I think it's important to understand that the Dodd-Frank Act provided that prior to the appointment of a director, some of the powers of the Bureau could be exercised by the Treasury Secretary. And these included rulemaking under federal consumer laws that predated Dodd-Frank, very important laws like the Truth in Lending Act, the Fair Credit Reporting Act, Home Mortgage Disclosure Act, conducting supervisory examinations of banks with assets of over $10 billion, and taking enforcement actions with that category of banks. And prior to the January 4th, the actions taken in the Bureau's name referenced this power and presumably were approved by the Secretary of the Treasury or his designee. Now, of course, all of the Bureau's actions are going to be taken on the Director's authority. And if that authority is held illegal, all of the Bureau's actions, including those that previously could have been taken under the Treasury Secretary's authority, will be invalid. So as a result of the recess appointment, what previously had been clear power to exercise some of the Bureau's authority has been replaced by significant uncertainty with respect to all of the Bureau's authority. To take an example, the remittances rule that is going to go into effect on February 7th and that the Bureau just issued could be challenged on this basis, even though it could have been issued under the Treasury Secretary's authority if the recess appointment had not occurred. And the same is true of the mortgage underwriting rule that is now being finalized by the Bureau. So you have a situation where actions that would have been lawful, at least couldn't have been challenged on this authority basis before January 4th, are now going to have a significant cloud over them, and we believe there's a very strong chance that the courts will find them unconstitutional, find the recess appointment unconstitutional. If that happens, what's the effect? And the legal answer is clear. All of the Bureau's actions will be invalidated. And the practical effect is just as dramatic as the legal effect. There is a real possibility of gaps in consumer protection. Punishments that the Bureau imposed on fraudsters, everybody agree, were ripping off consumers, will be overturned. New regulations, such as the one I mentioned, will be null and void. Actions that could have been accomplished lawfully by the Bureau acting under the Treasury Secretary's authority, or by the Bureau working in tandem with the FTC and other agencies, will be sent back to square one. Second, real confusion and uncertainty for legitimate businesses. What businesses want, as Ambassador Gray said, is clear rules of the road. But they'll have exactly the opposite. If the courts declare the appointment invalid, should they comply with the rules that applied before the director was appointed? Should they comply with the new standards, even though they're now legally questionable? With the director's appointment invalidated, who's going to provide guidance to businesses about what they should do? There's going to be a prolonged period of uncertainty. And finally, duplicative compliance costs. To the extent new rules become invalidated and businesses have to go back to restructure their operations to comply with old rules, that means unjustified and excessive costs. And that's money, of course, that businesses could have used to create new jobs, to expand their operations, something that our economy needs. So the overall effect of the recess appointment is to put at risk significant consumer protection actions that would have rested on firm authority. And the potential consequences are going to hurt consumers, businesses, and the entire economy. Thank you, and I look forward to answering the committee's questions.
Mr. Gerhardt.
Thank you for the opportunity to be here today. I greatly appreciate the invitation. At the outset, let me just make two quick personal comments, if I may. First of all, as a constitutional law professor, I have to tell you that there's nothing more special, no greater honor than there is for me to be able to participate in a hearing like this. So I am grateful for that. At the same time, I speak for myself today and, of course, for no one else and not for my institution. Nonetheless, let me at least say that as somebody who teaches at the University of North Carolina Law School, I do want to state for the record that Mr. Gray is a North Carolina treasure. So I hope he will allow me that. Of course, I also understand you've got my written statement, and I don't want to go back through that in any detail. I do want to take my brief time today to focus on a couple of issues. The first one of which, of course, has to do with the major question that has concerned this committee and other people, and that is the question about whether the time during which the President acted to make his recess appointments was, in fact, a recess in a constitutional sense. Let me just point out for the record what we haven't said so far. To begin with, courts generally treat that action with a presumption of constitutionality. Second, it should be noted that virtually all authorities agree that a recess is not a fixed time and that the President of the United States does have an independent judgment about whether or not there is a recess in a constitutional sense. Moreover, almost every authority, and I think almost every president, has agreed that in exercising judgment about questions like this, the President is entitled to take what we call a functional approach, a functional analysis. That is to take competing considerations into account. And that is, I think, what the President of the United States has done. At the same time, the President of the United States, I think, has understood that if, in this circumstance, we assume that the break that he counts as a recess was not a recess, then the Senate, in effect, has the power through pro forma sessions to completely nullify the recess appointment authority. So in a sense, the President, I think, has acted sensibly and soundly to defend his own prerogatives. Beyond that, I think the memorandum from the Office of Legal Counsel that provides one basis for his actions is a perfectly sound document. It notes, for example, that over history, presidents have taken a functional approach to determining whether or not they should exercise this power. Beyond that, the document notes that this is not the first time that there's been a disagreement between the President and the Senate over whether or not there's a recess. It also notes that courts, generally speaking, are very reluctant to interfere with the President's exercise of judgment in this context, all of which leads me to think that the President's case here is a sound one and a credible one. Beyond that, we have before us a question about the President's duties under the Constitution. Recall that the President takes an oath to take care to enforce the laws faithfully. And no doubt in this case, the President considered that if he didn't act, there would be laws left unenforced, laws that he obviously is trying to do what he can to put into implementation. We've talked a lot about uncertainty today, but I think it's fair to say that the uncertainty doesn't just cut in one direction. There are a lot of Americans, I suspect, who are uncertain about what's happening with the National Labor Relations Board, what's happening with the Consumer Financial Protection Bureau, and they're concerned about what happens if these laws are not enforced, if there are certain regulations that are not made in this context. I suspect that the President took all those concerns into account in determining on balance that the time was right for him to act. Lastly, I would just want to emphasize that if we look into the past, we will find, generally speaking, the courts don't overturn recess appointments, I think even like those that we're talking about in this case. I think the doctrines that pertain to case or controversy, I think the timing of a lawsuit are all such that it is highly unlikely that these recess appointments will in fact be overturned. But I should also point out that the Constitution provides a check, actually two checks, on the recess appointment authority. One is that they're temporary. The other is that the man who made them is politically accountable. So I think that we should keep in mind the full set of checks and balances when we talk about the constitutionality of what's occurred in this circumstance. Thank you.
Mr. Rivkin.
Mr. Chairman, Ranking Member Cummings, it's a pleasure to be before you. Emphasize that I'm speaking on my own behalf and not on behalf of my law firm clients. Let me briefly walk through what I consider to be some of the most unfortunate implications of what I consider to be, together with a number of other individuals, unconstitutional use of recess appointments by the President. First, as is the case with most separation of power disputes, they transcend the immediate circumstances and immediate agencies involved. I'm not going to repeat the prediction that you've heard that the courts will not, so much with due respect to Professor Gerhardt, would not overturn the recess appointments as such, but would basically nullify, hold null and void all of the regulatory products that would have been put out by the two agencies and therefore during the tenure of those two individuals, and therefore would accomplish nothing useful. I'm not going to talk about massive regulatory uncertainty. Let me talk about the constitutional implications, which to me, as somebody who cares passionately about the Constitution, are most important. And the most important problem here is that the President's actions put at risk Congress's own rights and prerogatives. The most important one, of course, and we heard about it earlier today, is the scope of congressional power to determine the rules of its proceedings. Until now, it's always been assumed that Congress alone can set the terms of its sessions and evaluate compliance with the rules. The President's functionalist approach effectively strips this power from Congress, claiming that he may look past Congress's own judgments and determine for himself their legal effect. What I would want to tell you is that approach, if allowed to stand, would empower presidents of both parties to cast doubt on nearly any congressional action, and in the process decisively tip the balance of power away from Article 1 to Article 2. Now, we've heard a little bit of a discussion this morning about how that would work in the context of appointments. The President indeed can staff the entire executive branch with make-believe recess appointments and therefore eviscerate this very important check and balance that the framers placed in the Senate. But let's talk about legislative power, power to pass legislation as such. Let's forget about appointments for a second. The President, of course, as we all know, is a participant in the legislative process, but he does not have an absolute veto. Presidential vetoes can and have been overridden by veto-proof majorities in both houses. But under the President's functionalist approach, the President, for example, might take the position that any legislation that passed without a quorum in the Senate, and as we all know, much of a Senate legislative business is done without a quorum, or for that matter, without even a vote being taken by unanimous consent. In that respect, there's nothing particularly unusual about pro forma sessions. So the President can take the position that that legislation, piece of legislation, was unlawful and therefore can be disregarded with impunity and without invoking even the need to veto it. Another area where a same problem can occur, and the President can determine for himself when Congress is in recess, concerns a so-called pocket veto. As we all know, the Constitution provides that if a bill is passed by Congress and not signed by the President, it becomes law within 10 days of a bill being submitted to the President. Sunday is accepted unless Congress, by its adjournment, prevents the return of a bill, in which case the bill dies. Now, if the President is able to determine for himself when Congress is in session, he can take the position that Congress is in recess, and therefore he can, in effect, pocket veto any legislation he dislikes without paying any political price. Now, I've heard a little bit of a discussion today. Let me say first about the legal opinion, because it illuminates the broader point I'm going to make. With all due respect, it's the worst opinion I've ever seen OLC issue. The first 18 pages of it go through OLC precedent that nobody is disputing. The analysis in pages 18 and 19 is entirely conclusory. It basically takes what animates this opinion, to put it very crisply, is that somehow the President is entitled to recess appointments. With respect, it's bunk. A recess appointment is a gap filler. It's available to a President when there's a recess. If Senate so wanted, it can arrange for itself to be in constant session 24/7. The President does not have a power to secure a given number of recess appointments. No, with all due respect to Congressman Cummings and his colleagues, the President has a right to populate the executive branch with the people he finds congenial. I'm actually sympathetic to that view, having served in the executive branch, but if the Senate wishes to disapprove or not vote on the President's nominees, the President would be very lonely. That is perhaps unfortunate, but that is not a reason to warp a Constitution. So there's a great deal at stake here, and we're talking about probably the greatest aggrandizement of executive power in American history. And it's amazing to me that people were very critical of a previous president in this area, unjustly in my opinion, seem to be quite silent now. Thank you.
Thank you. Mr. Carter.
Thank you, Chairman Issa and Ranking Member Cummings, for inviting me to testify before the committee today. As a direct consequence of the appointments of members Richard Griffin, Sharon Block, and Terrence Flynn on January 4, every administrative decision and every administrative rule or regulation implemented by the National Labor Relations Board will be subject to appeal or attack. This vulnerability will necessarily impact the agency's ability to accomplish its primary mission of promoting industrial peace and stability in labor relations and minimizing the likelihood that labor strife will negatively impact interstate commerce in the United States. As recently as January 26, the chairman of the NLRB reportedly told the Associated Press, or the AP reported, that the NLRB would push for new rules that give unions a boost in organizing members. The chairman is quoted as stating, "We presume the constitutionality of the President's appointments, and we go forward based on that understanding." The chairman's reference to the constitutionality of these appointments is a critical issue. As you have heard today, if the appointment of the 3 recess members is not constitutionally sound, the actions of the NLRB will be ultra vires, and every decision, rule, regulation, or official action of the agency will be subject to legal challenge on that basis. This is because of a June 2010 United States Supreme Court opinion called New Process Steel versus NLRB. In New Process Steel, the employer appealed from an adverse decision by the NLRB and the Seventh Circuit Court of Appeals. The primary issue resolved by the court was whether the NLRB could issue an administrative decision with 2 members resolving the case. The statute contemplates a full complement of 5 board members, one of whom is the chairman. Section 3B of the Act permits the board to delegate its authority to a panel of 3 members. When the administrative decision in New Process Steel was entered, there were only 2 individuals in place at the board, the chairman and 1 member. In its decision, the Supreme Court held that in order for the NLRB to issue a viable decision, at least 3 individuals must compose the board itself. It is axiomatic that any decision or official action taken by an NLRB composed of 2 or fewer individuals is ultra vires and cannot be enforceable. The court rendered this decision despite the fact that the 2-person board had resolved almost 600 cases, and fully appreciating the board's argument that it had a desire to keep its doors open. The court concluded that the statute did not permit the agency to, quote, create a tail that would not only wag the dog, but would continue to wag after the dog had died. The federal courts will necessarily hear the argument that parties appearing before the NLRB have been adversely treated by the wagging tail of a deceased dog. If the courts ultimately conclude that the recess appointments of the board were accomplished unconstitutionally, then the decisions and regulations the agency issues that result in adverse impact to any party are vulnerable under the new process precedent. If the 3 recess appointees are not validly appointed, then the decisions and regulations emanating from the board as currently composed are actually only being issued by 2 individuals, Chairman Pierce and Member Hayes. If only 2 persons comprise the board, their action is ultra vires. The obligations of this agency to strive to accomplish its mission should not be taken lightly. The agency is created by Congress, and it does not and should not seek to enforce or advance any private rights. Rather, it is a public agency that was created to, quote, protect the public welfare, which is inextricably involved in labor disputes. The Supreme Court of the United States has held that the board, as a public agency acting in the public interest, not any private person or group, not any employee or group of employees, is chosen as the instrument to assure protection from the described unfair conduct in order to remove obstructions to interstate commerce. The consequences of the recess appointments of members Griffin, Block, and Flynn, through no fault of their own, are that in every litigation resolved by the agency and with regard to every rule or regulation implemented by the agency during their tenure, anyone who desires to challenge that action may under due process steal. Regardless of whether those challenges are successful or not, the agency's mission to minimize labor strife and to remove obstructions to interstate commerce will be frustrated.
Thank you. I'll recognize myself for first round of questions and follow right up with Mr. Carter. How did the NLRB only have 2 members at that time of that decision, the Steele decision?
At the time of the new process Steele decision, the Senate was continuing with pro forma sessions, and there was it was impossible to make any recess appointments. And
to your knowledge, did the executive branch issue some sort of a statement on that, challenging the Senate's ability to have pro forma sessions at that time?
I'm not aware of that, sir.
Ambassador Gray, you're pretty significant to today's hearings, because when you had the questions before you, you reached a different conclusion. Would you tell us a little bit about how you, as I think Mr. Rivkin and Mr. Carter both did, how you could think again and agree with the decision? Is there any way you could agree with the decision made by counsel on behalf of the President that allowed these extraordinary events to occur, particularly as to the 2 or 3 NLRB people, 2 of whom had not even been given time to be considered by the Senate?
Well, the trump card is held, at least in a theoretical sense, by the Office of Legal Counsel in the Department of Justice, and they came out with this ruling, which, gosh, I don't think we would have permitted, because, as I said earlier, it acknowledges a litigation risk, which we would have said, no, that's not good enough. Give us an answer that doesn't throw the whole thing into a cocked hat. So for that reason alone, I think that I would never have allowed this opinion to issue in the form that it issued. Beyond that, if you look at footnote 13, it's very disingenuous in my view. It says we have never formally taken a position that there's any lower limit to the time necessary to justify a recess appointment. And, in the 4 years I was in the White House actually a total of 12 years, watching and then dealing directly with appointments of this kind, never once was there any hint that the time period could be less than 3 days. Certainly even when I was in the White House, not less than 2 or 3 weeks. It hadn't gotten down to the 10-day limit. And there's plenty on the record to suggest that it is a 3-day, and of course we have the Constitution giving the House authority to refuse a recess shorter than 3 days. So But to repeat, the litigation risk red flag in this opinion is one that really disturbs me a great deal.
Now, we earlier heard, and from personal knowledge I know, that the House did not grant the Senate the ability to be in recess. Assuming that the House's authority now has been waived, that we no longer have that authority, how do you square that? How does the House lose its constitutional authority to have to acquiesce to the Senate going into recess and vice versa?
Well, that's one of the infirmities of this opinion. It's saying that, and I know there's a difference of opinion from a professor at my alma mater, but what he's saying.
If you were still there, you would have been updated on the new Constitution,
I would have been taught better than I was when. No, I just don't understand, Mr. Chairman, how anyone can say that the President has the power to decide when you or when the Senate is or is not in recess. And I think
that's the question I guess I'll beg for all of you. The Senate is not the only question here. Isn't the question whether or not the House's prerogative guaranteed within the Constitution was in fact preempted by a decision that not just that the Senate was somehow acting not available. I could understand that if it was a question only of is the Senate really in session or not. But how do you square, how do any of you square the House not acting as constitutionally we have to allow a recess? Even if that chair were vacant day after day after day, wouldn't it be true that the House ultimately has an equal share in determining whether or not there is a recess?
If I may take a
Please,
step at
Mr. Rivkin.
Mr. Chairman, you're absolutely right. OC opinion somewhat disingenuously claims that the constitutional language you are talking about, Section 5, Clause 4, really deals with the relationship between the two houses of two parts of Article 1. So you may not be in recess for purposes of intra-Article 1 relations, but you're somehow in recess under the functionalist analysis vis-a-vis Article 2. I think it's an indefensible position. And
by the way, we sometimes think the Senate is in recess when we send bills over there. I made that clear to Senator Lee, that we often wonder what they're doing when we send them over and they die there. But isn't this a very straight, and I'd like to have anyone who disagrees, very straight question of the Constitution and whether or not the House gave its permission for a recess?
Absolutely. There's not much original founding era history in explaining why that section was created, but clearly it is created to ensure that there is a continuous and agreed upon functioning of Article 1 as a branch. So it is there for a reason. And let me also say the following, that gives you, and I'm remiss for not mentioning it in my remarks, you have an independent injury by virtue of the President's unconstitutional behavior, quite aside from usurping the Senate's confirmation power. He has effectively vitiated your power to deal with your peers in the Senate because it may be an important bargaining chip in some future procedures. And the problem with the President's analysis, it has no meaningful limiting principle. And you mentioned this point in one of your questions to Senator Lee. The President can say, you're in a pro forma session today. I like what you did. You passed the payroll bill extension. Therefore, you're not in recess. But in the next pro forma session, even though you're operating under the same standing order, exactly the same opportunity by unanimous consent to accomplish anything, because you didn't do anything, you're not in session, you're in recess. The same can be said about any of the Senate sessions.
Thank you. My time has expired, but I want to make sure all witnesses got to answer. Mr. Gerhardt, I think you might have a different view.
I appreciate that very much, Mr. Chairman. Thank you. Just two quick responses. The first is to remember what it means to say that the President has an independent judgment about the constitutional meaning here. It's not to say that each of the other branches don't have their own respective say, and his isn't something that binds you, but at the same time, I think what it means to say is he doesn't feel bound by what your independent judgment may be. The second thing is what is occurring, I think, in this debate is sort of like two trains or ships passing in the night. Essentially, I think what the Senate and perhaps the House have done is they've made a decision to place form over substance. And clearly what the President has done is decided to put substance over form when it comes to making a decision in this particular circumstance.
I thank the gentleman for his opinion. I'm glad I have a different alma mater. Mr. Cummings is recognized for 5 minutes.
Thank you very much, Mr. Chairman. On May 2nd, 2011, 44 Republican senators sent a letter to the President of the United States to voice their objection regarding the Consumer Financial Protection Bureau. The Republican senators did not express concerns regarding the qualifications of a particular nominee for the CFPB director position. Rather, the gang of 44 Republicans objected to the fact that the Dodd-Frank Act is now the law of the land, and that the Consumer Financial Protection Bureau would be able to protect consumers from unscrupulous mortgage servicers, payday lenders, and debt collectors once the director was installed. Now, Mr. Gephardt, I'd like to point your attention to slide 3. And here's what those 44 Republican senators actually stated, and I quote, "As presently organized, far too much power will be vested in the CFPB director without any effective checks and balances. Accordingly, we will not support the consideration of any nominee, regardless of party affiliation, to be the CFPB director until the structure of the Consumer Financial Protection Bureau is reformed." Mr. Gephardt, in your opinion, does it raise concerns that such a large block of senators would declare so openly that they are boycotting the constitutional confirmation process, even for highly qualified candidates?
I think my reaction is basically that these senators are, of course, free to express their judgment. And the size here may be somewhat significant in that they comprise a minority within the Senate. But at the same time, there are all sorts of checks and balances, not just across branches, but within branches. And I think that, and so I would certainly defend and support the fact that they've got the freedom to make their judgments clear. But as the statement itself suggests, what they want is reform of a law that's already reform to a law that already exists. So the President's job is not to enforce a law that hasn't yet been passed. The President's job is to enforce a law that actually is already on the books. And so I think that's partly what he's undertaking here, is to do what he can to implement or to make possible the fullest implementation of this agency or this Bureau's function.
Now, in your written testimony about the President's recess appointment, you state, and I quote, "The persistent obstruction of his nominations to both the NLRB and to the CFPB forced him to consider appropriate responses and all possible harms arising from his failure to act, as well as the failure of the Senate to act on any of his nominations and the ensuing harm to the American public and to the enforcement of the law." Looking at slide 4, on July 19, 2011, the New Republic quoted Thomas Mann of the Brookings Institute as saying, Senate Republicans insist that a legitimately passed law be changed before allowing it to function with a director, a modern-day form of nullification. There's nothing normal or routine about this. But, Mr. Gephardt, do you believe that President Obama acted constitutionally in making the recess appointment to the Bureau?
I do, and I've stated that in the written statement. I obviously have repeated it here orally today. And as far as Mr. Mann's comment is concerned, I think, again, it reflects the kind of checks and balances that we have. This is a very dynamic process. And this is exactly what we're seeing today, is checks and balances in operation. This is how it works. You can pass a law, but I think, as Senator Lee pointed out, there are various things that could be done subsequently if people think differently. But the important thing to understand is it's all done within the process, and I think the President acted within that process.
Now, if the CFPB director position had not been filled, the Bureau would not have been able to use its new powers to protect consumers from deceptive mortgage servicing, payday lending, and debt collection practices. Does the President have a duty to make sure that the consumer protections enacted by Congress are executed?
Obviously, I think the answer to that is yes. I think he does have a duty to do that, and I think that's partially not just constitutionally obliged on his part, but this is where he might also say or think, look, there's a lot of harm that's done from the fact that I can't get this law implemented, and he's trying to redress that harm. So I think he's constitutionally entitled to make those judgments.
Thank you very much.
Would the gentleman like additional time to ask about the NLRB?
But thank you for the additional time, but I do.
The gentleman has an additional 30 seconds.
Mr. Gephardt, are you aware of any instance where a large group of senators vowed to the President that they would block any nominee to a federal agency unless changes were made to the agency's enabling act?
That is a great question, and I have to say I can't think of anything off the top of my head, but that may not mean very much.
No. Very well. Thank you, Mr. Chairman.
I so much miss Senator Byrd. I'm sure there's a quote somewhere that's on topic. With that, we recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. I also want to thank the gentleman from Oklahoma for his courtesy. Professor, is there a different definition of recess depending upon which party is in power?
I think the answer would be no.
And one of the good things about the law is hopefully it provides order and predictability for those that come. So what's the new definition of recess for future Republican presidents?
I think it's actually pretty much the same. Keep in mind that the president here is acting against a backdrop where we have more than just the OLC opinion that's expressing a judgment about recess. There is, for example, the 1905 report from the Senate Judiciary Committee that essentially says that the President may treat as a recess a period of time in which the Senate's unable to receive or act on nominations.
Well, let's analyze that for a moment. The two NLRB names were given on December the 15th, and they were recess appointed on January the 4th. Do you think that now, talismanically, 2.5 weeks is enough time to demand that the Senate act on something?
Obviously, that's not my judgment call to be made.
Do you think if a president were to conclude that 2.5 weeks was enough time for the Senate to act on something, that would withstand constitutional scrutiny?
Well, if you're asking me yes, I think the answer is going to be yes, because I think this falls within the discretion of the President.
So 2.5 weeks, what about a length of time in terms of recess? Because 10 days, according to you, is too long. 3 days. Can the recess be less than 3 days?
I think as a practical matter, the answer is going to be yes, because that's what the President's using here.
Can it be less than 1 day?
It might well turn out to be the answer is yes.
Can it be over the lunch break?
But let me point out that the fact that something might be constitutional doesn't mean you have to do it. And so
I agree. The Constitution says he shall have the power. He doesn't have to do it.
And so he might conclude as a practical matter that he does have an opportunity to make a recess appointment.
I'm trying to get a sense of if our country were to be fortunate one day to have a President Langford from Oklahoma, that if the Senate...
That would be good fortune.
If the Senate were on lunch break or taking a nap, as has been known to happen from time to time, is that a sufficient length of time by which the President can use his recess appointment power?
Well, again, clearly, practically speaking, I think he can make a judgment, and perhaps most people would make a judgment, that these breaks that you've just described are probably not recesses for fairly obvious reasons.
I'm looking for the law.
But we're talking about the pro forma sessions here, and that, I think, raises a slightly different
that gets to my next point. Right. How can the payroll tax cut be effective if they were on recess?
I think the answer to that is by the time when the President makes this judgment, he obviously has concluded that the Senate is not in a position to be able to act on these nominations, and he thinks that
But how could they act on nominations which weren't even given to them in a timely fashion? They got them on December the 15th, and they didn't even have the proper paperwork.
I understand that, but let me just remind you what the Recess Appointments Clause says. The President may fill up all vacancies. And so there are vacancies that were created for one reason or another, and I think under those circumstances, he may be able to choose.
Do you think the founders had a 2-hour recess in mind when they drafted that clause?
I don't know what they had in mind.
Well, but you're a constitutional law
I can
expert.
tell you
What do you
this.
think?
I think they didn't have a fixed period in mind.
Do you
That seems to
think
be
they envisioned
supported.
2 hours?
Like I said, I don't think they were thinking that at that level of detail. I think they thought, to the extent they did address that, it's not a fixed period. And what we're talking about here is a circumstance in which the president, like most presidents, approaches this issue in a very practical way, balancing the competing considerations.
Well, speaking of the president's practicality, he referred to Ambassador Bolton as being damaged and having his credibility undercut because he was a recess appointee. Do you think the same analysis would apply to his recess appointees, that they are damaged and have less credibility?
You mean damaged politically?
I don't know how the president...
Yeah, I was going to say, I'm not sure I understand the context of the statement, so I don't know that I could tell you what he was thinking or why he said that. But I think that what happens, of course, is the Constitution and politics converge all the time. And in a circumstance like this, where the president makes a judgment, it's not just going to have constitutional ramifications, it'll have political ramifications.
Well, you keep using the word judgment, and I'm trying to get to what the law is, because the beauty of the law is it instructs future people what they can and cannot do. So I'm not as interested in someone's judgment as I am what the law is going forward. For the next president, is there any time limit associated with recess?
I think the answer would be probably yes, because I think you have to put all this into context.
It's less than 3 days, though.
I don't know if it's less than 3 days or not, but I do think that it's a matter of context. It's a matter of what are the practicalities at the moment the president's making that judgment. Keep in mind that the president's making this determination based not just on the text, but also based on the recognition that recess is not a fixed concept. And beyond that, he's also making a determination, I think, based on the laws he's got to enforce, and the text that I think that gives him this authority, and the recognition that if he doesn't act, then in a sense what's happened is the Senate might be able to literally eviscerate his power.
I'm out of time, Mr. Chairman. If I could have 15 seconds to ask my final question, and I promise it is my final question.
Asking unanimous consent. Without objection, the gentleman is given an additional 15 seconds.
Thank you, Mr. Chairman. You mentioned judgment. Are you moved at all by the fact that the Senate is controlled by the same party that controls the White House, and the third NLRB appointee, the Republican appointee, was never given a hearing, was never scheduled a hearing by the Democrats who are in charge of the Senate? Because some of us would be suspicious of collusion, that you just don't schedule it and you wait until a nap takes place and then you go ahead and make a recess appointment.
I would just say this with all due respect. The politics of this are not my concern. I try to look at this strictly from the vantage point of what the Constitution might have to say about this and what the constitutional law might be. So the parties involved, which the President, the Senators, the nominees, are not factors in my calculation.
Thank you, Mr. Chairman.
I thank the gentleman. The gentleman yields back. We now recognize the gentlelady from the District of Columbia, Ms. Norton, for 5 minutes.
Thank you, Mr. Chairman. Mr. Gerhardt, I'm not going to give you any law school hypotheticals or worst-case absurd examples, even though I regard my prior profession, my real profession as a professor of law at Georgetown University Law Center. I still go over there to teach once a week. I look first to the written legal advice the President received from the Office of Legal Counsel. I look there because the Office of Legal Counsel is considered, I think, by most of us to be the least political office in the Justice Department, because the job of that office is to keep the President from getting in trouble. And if someone would put up some words that I asked the staff to get for me from his analysis, allowing the Senate to prevent the President from exercising his authority under the Recess Appointments Clause by holding pro forma sessions would be inconsistent with both the purpose of the clause and historical practice in analogous situations. Now, this opinion appears to raise serious separation of powers questions. Let me ask you, since I'm in a Congress that is constantly looking to the framers, whether you think the framers intended Congress to overturn a law by refusing to confirm an appointee to run an agency? Do you think the framers had that as a possibility in mind?
Well, let me just say at the outset that, of course, the statement here is essentially an iteration of what I've been saying. And I think the OLC memo, with all due respect, is a perfectly good example of the kind of work one gets from OLC, which is not just nonpartisan, but they try and look at all the competing sides and come out with their judgment. In terms of your question, I think the framers sort of told us what they think about that circumstance when they set up the Constitution. Obviously, laws are made a certain way in compliance with Article 1. That's how laws are made. But there may be other factors that come along the way, funding and other things, which are made through other laws. But in terms of nullifying a law, one chamber of Congress doesn't have the authority, I think, to nullify a law. Laws are made through compliance with bicameral and presentment clauses.
Well, I was intrigued by, therefore, I always want to look and see what does the other side say. So I wanted to see what a former Office of Legal Counsel had said under comparable circumstances. Now, this president is known for his patience and unflappability, some would say criticized for his patience, particularly with this Congress. Here, let's take the Office of the Consumer Bureau. The response to one of the most important responses to the most serious economic crisis in our lifetime, or at least lifetime of many of us, victimized millions of Americans. This agency has not been functioning as a full agency because there's been nobody to lead it. Now, there's one thing to be patient. It's another thing to become a wimp and to let your duty to attend to the laws vanish in the face of a Congress which simply refuses to do what has largely been done in the past. So in looking to prior legal counsel, the staff found me two former Assistant Attorney General, John P. Elwood and the former Deputy Attorney General, both subscribed to this statement. The Senate cannot constitutionally thwart the President's recess appointment power through pro forma sessions. The President should consider calling the Senate's bluff by exercising his recess appointment power to challenge the use of pro forma sessions. This President appointed, did not in fact move forward with one appointee that the Senate disagreed with. All right, he says to the Senate, here's another one I have for you. And the Senate says, all right, you've come up with somebody who's fully appointed, and tell you what, we disagree with the underlying law that this appointee is to administer. It does seem to me that the notion of calling the Senate's bluff comes into play at some point, and I'd like to know your view of that.
Well,
if the President had simply allowed this to go on indefinitely, instead of finally calling the question, take it to court, do what you want to. But I'm calling the bluff now after virtually almost 4 years in which this particular bureau has not been able to function.
If the President...
Would the gentlelady yield for just a second? Did you mean to say 4 years on this agency?
Almost.
No,
all right.
Dodd-Frank was a year ago.
I stand corrected on the time. My point remains.
The gentlelady will have an additional 30 seconds.
I thank the gentleman for putting into the record the correct number of years, whatever it is, and whatever the staff finds, I'm sure would be the case. The point I made by introducing this was that the President's patience had been quite exhaustive, and that even members of a prior administration who had held this very office had said at some point somebody's going to have to, quote, call the Senate's bluff. I think that's what what was done here, and I ask for your response with respect to that, or should he just have let it go on, maybe for another 2-4 years, however long it might have taken?
And I do think that that opinion reflects the fact that the basis for the President's actions are not uniquely partisan. That is to say, there's a wider, more solid ground on which he's operating. But to directly answer your question, I think that if the President, faced a situation where he knew that if he didn't act, there would be these harms that would continue to occur, that the Consumer Financial Protection Bureau would be left unable to perform some of its most important functions, and that would leave, in his judgment, the American people harmed. So that's the harm that he's looking at there. He could look at this other situation and say, look, if I act, what harm might there be? Clearly, in his judgment, he didn't think there was as much harm by acting. In fact, he thought he would actually be producing some good. That's not an unreasonable stance for him to take. So in fact, to stand pat simply would have allowed harms to build up over time and the law to go unenforced.
I thank the gentleman. I now yield 5 minutes to the gentleman from Oklahoma, Mr. Lankford, and would ask him if he'd yield for 15 seconds.
I absolutely would, Mr. Chairman.
I just want to make the point that one thing I've seen a pattern of today is that every question seems to be about Consumer Financial Protection Bureau and none about people whose applications arrived in the Senate, two people whose applications arrived in the Senate formally after they were sworn in. Yield back.
Thank you, Mr. Chairman, and that is exactly where I want to be able to land on it. It is interesting to me that a lot of this conversation is about could this be permissible? Is there some person out there somewhere? Obviously, the statement there from the Bush administration that there was an individual that considered this. The Bush administration did not take that advice. They took the advice of others over the top of that and said, no, that's not legally appropriate. What this has done is for political expediency of the President to make him look tough, to fight against the allegations that you've been weak in the past. He's got to get in the election year and try to look real tough and like I'm going to force some things down their throat so I can look manly, but it opens up all of this litigation. And every action of the NLRB suddenly is going to go to court, and it will cost him millions of dollars so he can politically look better in a campaign year. But this will drag out all of these cases for years now in litigation. It's frustrating to me. And that we have to sit and discuss what are the issues of litigation when this was a settled issue 2 years ago. I go back to the steel issue, the new process steel with Deputy Solicitor General Neil Cato. As I go back through the oral arguments that I pulled up, he looks directly at Chief Justice Roberts doing oral arguments before the Supreme Court, and Chief Justice Roberts discussing the NLRB and the vacancies. Ask a point-blank question. And the recess appointment power doesn't work. Why? To which he responds, this is the Obama administration Deputy Solicitor General, responds back to the Chief Justice of the Supreme Court, the recess appointment power can work in a recess. I think our office has opined that the recess has to be longer than 3 days. Now, this seems fairly clear to me that this is not an issue about recess appointments and does the President have the power to do recess appointments? He absolutely has the constitutional power to do recess appointments. This is not a recess. This is a constitutional issue. This is an issue of can the executive branch define for the Senate when they're in recess and when they're not? Is this the power of a monarch to reach into the legislative branch and say, you are in the way, I'm going to now declare you in recess, and I'm going to put in who I want. And on top of that, to drop their names in on the 15th of December, and then to say, it's been long enough, 2 weeks later, I've waited for you all this time, I'm now going to go ahead and put them into place, seems absurd on its face. So while we can discuss all the issues of the CFPB and the dynamics of the politics of it, in reality, the biggest issue that sets the largest precedent is the NLRB case. If the President has some power to ignore the advice and consent of the Senate, and if he can in one day drop a name in, and before hearings are even scheduled over some weekend in the future, or has been opined already over a lunch break, can now declare, I'm not in communication with the Senate, they're in place, do it in January, and ignore the advice and consent now for 2 years, and can fill all vacancies, why can't a future president, some January over a weekend, fill every single court, all of them, and say, this is my recess responsibility, the precedent has been set over here, that was ignored by the Senate, the courts have upheld it. What would slow down some future president from doing that? Anyone is welcome to answer that. Let me take some different opinions here. Go ahead.
Well, let me say nothing would prevent this from happening. In fact, I mentioned in my oral remarks that would fundamentally recast not just the constitutional balance, but it would, in effect, enable the president to put into office people who otherwise would not get confirmation for reasons that have nothing to do with partisanship. You really can have an executive branch comprised of political hacks who come in, know they're only going to be there during the limited term, and do the president's bidding and feel completely unaccountable.
So at that point, advice and consent is gone.
Advice and consent is completely eviscerated. Again, the problem of the functionalist approach is, aside from the fact that it's not bound in the text, it has no limiting principle. And the notion, I mean, I hate to engage in law professor-like hypotheticals, but under the notion that if you have a genuine emergency, you can disregard something, why couldn't you disregard an appropriations rider or a statute which does not give the president to draw money from a treasury? You say, there's an emergency. I'm going to draw power from treasury because I want to enforce the law. The House passes appropriation riders all the time that prevent agencies from spending their funds. The president can say, I don't care. There's a statute in the books. There's an appropriation rider which says EPA cannot do something, but I don't care. I'm going to use the money. There's no difference.
And with that, we recognize the gentleman from Massachusetts, Mr. Tierney.
Thank you, Mr. Chairman, and thank all of you. I think we've pretty thoroughly gone over the constitutional aspects of this situation, and I think it's been enlightening, at least for me, I hope for my colleagues as well, on that. I thought I'd take a different look at that, stepping away from the constitutional issue directly on that. Ambassador Gray, you obviously have looked at this thing from both sides, you know, given your President Bush's recess appointment on that basis, and also your White House counsel position. Back in March of 2005, there was an article in the Hotline that reported a statement from you, and I'll quote it: I believe the use of the Senate cloture rule to permanently block nominations conflicts with the Constitution's advice and consent clause. Do you remember making that statement?
Yes, sir, I do.
How do you feel about that today? Do you agree with it, or have you changed your mind?
The statement was made in the context of judicial appointments. There had never been a filibuster of a judicial appointment for 200 and whatever years, so I thought it was perfectly appropriate then, and I still think it's not appropriate to filibuster judicial nominees. But that's a different issue, both in terms of who the nominee is to, say, the Supreme Court versus a nominee to the NLRB. It's a different issue. It's also a different issue whether or not cloture should be used against the judge is a totally different issue than whether a president can declare recess whenever he feels like it under whatever criteria he wants to use. And I think it's important to say that I don't think the recess appointment power is a response to rejection. I take the point that, of course, the NLRB people hadn't even filled out their forms yet, but it's also true that Cordray was rejected. Now, it was rejected by a filibuster, but he was rejected. And the OLC opinion doesn't say that recess is appropriate to deal with the filibuster issue. I don't think the word filibuster appears anywhere in the Office of Legal Counsel opinion. So the recess is not an antidote to rejection. And, of course, there was contemplation in Dodd-Frank that there might not be a director confirmed, because the legislation provides specifically that the agency can do a whole number of things, but certain things it cannot do until there is a director confirmed by the Senate. And so it was understood that maybe there wouldn't be a director confirmed. Maybe the director would be rejected. That was understood by everybody who passed that legislation. So I'm giving you too long an answer. I should.
No,
but
we're here to get your information.
But I do think the filibuster issue was quite distinct. The Rule 22 issue is very, very distinct from whether the president has the authority to avoid the confirmation process and declare recesses whenever he feels like it.
Mr. Pincus, you made a statement at the beginning of your remarks that the Chamber of Commerce supports consumer protection. Is that correct?
Yes.
Okay. So I'm fair to say that you also made some comments about certainty, that the business community appreciates certainty in the implementation of the laws as they are on the books.
Yes.
Okay. When you look at the statute and you look at statements like those made by 44 Republican senators who wrote to the president vowing that they would block any nominee regardless of party affiliation, because they objected to the very structure of the Consumer Financial Protection Bureau. You see that statement, you know the law has been passed. It hasn't been fully satisfied yet because there's been no appointment. And then 44 members of a particular party come out and say, well, we're just never going to act on that, so you're going to be with that uncertainty for a long period of time. How does that impact your comments about Chamber's desire for consumer protection and your comments about the desire for certainty?
Well, I guess two answers, Congressman. First of all, on consumer protection, as I said in my testimony, there's a lot that the Bureau can do under the Treasury Secretary's authority. There are many rulemaking responsibilities that Congress laid out in Dodd-Frank, and there are many other rulemakings that the Bureau could undertake.
Well, if I could, just not to be rude, but because the time is limited, let me stop you on that point so we can explore it. What it won't be able to do, however, unless somebody is appointed, is identify and curb unfair, deceptive, and abusive financial practices. Won't be able to rein in predatory payday loans. Won't be able to ensure credit reporting agencies comply with consumer protections, won't be able to safeguard against abusive debt collection, and it won't be able to monitor private student lenders and non-bank mortgage companies and other financial institutions, just to name a few. So those you consider, of course I would, those you consider not important or not relevant?
No, they may well be important, but a couple of points. First of all, the FTC does have the power right now to act against unfair and deceptive practices, is doing it. In fact, this week announced a large, significant enforcement action on consumer debt collection, and it has been doing it right along and has devoted very substantial resources. So there's a bigger argument about whether or not, where the gap was that the Bureau was designed to fill. Much of the argument in the run-up to Dodd-Frank was, we're very troubled that the bank regulatory agencies don't focus on consumer protection with respect to the entities they regulate, which were banks. And we need to transfer that power to a new regulator that will focus on that regulation. That's the power that the CFPB had prior to January 4th and was exercising. As the legislation moved through Congress, it expanded to focus on other entities, all of whom are already regulated both at the state level and by the FTC. And the FTC has very, very broad power, and the state attorneys general certainly have very, very broad power. So all of the entities that you listed are already regulated both by the FTC and the states. So the question is, I think there's a question both about the gap and whether there is one, and we would suggest that there isn't, and that really the question here doesn't create uncertainty. And in fact, as I discuss in my written testimony, a huge amount of uncertainty is going to be created by the overlap between the state AGs, the FTC, and the CFPB, all of whom now regulate these same entities, and all of whom may regulate them in totally different ways. And you don't feel that the
failure or the statement of 44 says that they're just not going to appoint anybody on that basis leaves any uncertainty at all as to how that act is going to be conforming going forward?
Well, what it does is it means that particular part isn't going to take effect until there's some check, the same bipartisan check on the Bureau that exists for the FTC, the CFP, the Consumer Product Safety Commission, the SEC, the CFTC, and just about every other regulatory agency.
So the Chamber is okay with that, that being uncertain as to whether and when that part of the statute is going to be implicated?
Well, I think it's going to be uncertain for some time, and I think the question is going to be, can we get a regulatory structure that makes sense going forward?
Well, the question really is, are you going to get somebody appointed? But you're okay with there being no appointment, so I guess that follows in that you're okay with that part of uncertainty.
Your time has expired, but the gentleman may answer.
Congressman, I think what we're okay with is that the part of the statute that was effective and was being administered was being described, was being fleshed out. The idea that parts of the statute that wouldn't come into effect until a director was appointed wouldn't be fleshed out until a director is appointed makes perfect sense, because the business community is not now subject to them. The problem now is that the business community is placed in a very difficult situation where a lot of enforcement actions and regulations are going to be issued that legitimate businesses will feel they have to conform with, that may turn out to be totally invalid, and they may have to then spend a lot of money to go back to the status quo, because it turns out everything that's happened gets set aside by the courts.
Or it may not.
And with that, we go to the gentleman from Arizona who has been patiently waiting, Dr. Gosar.
Thank you. You know, Ambassador Gray, I would like to give you a quick moment to respond to Mr. Gerhardt in regards to his comments earlier about the constitutionality and how the process facilitated the ends meet are okay with the process.
Well, I don't know how long I have. No. I will stick with what I've already said and what Senator Lee said. If the President can just say, well, I actually think the Senate really is lollygagging around now and ought to be in session lunch, but they're not. The chamber's empty. And, you know, they rejected my nominee for exposition, and not by filibuster say, but by up or down vote, by a 20-vote margin. And I don't like that. And therefore, I see a recess opportunity here, and I'm going to name this person to this agency anyway. Now, that's not the way the Constitution is supposed to work. And there is no absolutely irreducible right to make and get nominees confirmed to, I think, maybe any entity except, you know, military. I want to hedge my thing on, you know, some diplomatic positions, Supreme Court. But for the average agency, I don't think there's any irreducible minimum right that the President has to say that there's going to be a recess anytime I say there is, and therefore I can just override the confirmation process. I don't think that's what the Constitution means. I think there's another point to be made here, not to belabor it, but the CFPB and the NLRB are creatures of Congress. They're your creatures. They're not creatures of the President. And if you don't want to staff them, I don't think you have to staff them. Now, in addition to them being creations of you, they are so-called independent agencies. Now, I have problems with the doctrine that any agency can be independent once it's set up of the President's control, but the President takes this view too. These are independent agencies. They're your agencies. Not only did you create them, but you, independence means you actually have the upper hand in controlling them. And if you don't want to staff them, you don't have to staff them, and you don't have to fund them.
So it brings me to my next point, Mr. Pence's. Staffing. We're business people. I was a dentist before. I'm impersonating a politician, you know, so a business, when we go through a staffing process, particularly when we have a new rule, we have to flush it out, what's right, what's wrong, and particularly when it's rushed through. I mean, I wasn't part of the 111th Congress, and I see some problematic issues, particularly with both sets of appointments. Isn't it getting it right that's the most important about process?
I think that's right, Congressman. I think getting it right is important. I also think, you know, my mother always said 2 wrongs don't make a right.
Thank you. Perfectly said. Ambassador Gray, over the history of our country, who's inflicted more harm to the Constitution, constitutionalists or the average person?
I'm not sure. Who's a constitutionalist? You're saying?
Well, I mean, we have attorneys that claim that they follow the Constitution, and we see it inflected upon the Constitution over and over again, the challenges that depart from the original intention from our Constitution. I don't see the average person making these claims a violation of the Constitution, but I do see attorneys with constitutional background who do make those.
Well, this is another hearing. Certainly, there are many of us who think that academia is the source of a lot of wonderful theories.
And the President was what?
Well, he was an academic. Often this gets translated through law clerks who get put out into the field, working for judges and influence judges. And I mean, this is a long conversation, but no, the public is not guilty of this. And part of the reaction of the last election is a lot of people in the public saying, well, wait a second. I mean, there's something out of kilter here, and what we thought about is limited government. There's something has gotten out of hand, and that, I think, is a valid point to raise, and it's not the fault of the average voter in America.
to me, if I'm the average guy on Main Street, if we're playing basketball, this is a blatantly flagrant foul in which you have timeout, you take a penalty, and you're excused from process, from playing the game at all. That's how bad this is. With indulgence of one more quick question.
The gentleman will be granted an additional 30 seconds, plus Mr. Gerhardt does want to comment in, too. We'll allow additional time for that.
Mr. Carter, I know in regards to the NLRB, you know, prior to this with the two members on there, most of these processes in which they were going to go through were really non-controversial. And now when we've had these appointments, how do you think they're going to respond? Are they going to still stay to the non-controversial aspects of what's before them, or are they going to go into the realm of the controversy?
Well, let's try to deal with this empirically. When Member Peter Schomburg and Member Wilma Liebman were left as the sole two members of the National Labor Relations Board, they came upon an agreement. It was the subject of the argument in New Process Deal, whereby they agreed not to decide any controversial cases, those cases that normally would require at least 3 majority votes to overturn prior board precedent. And they did so in a collegial fashion, despite the fact that Member Schomburg was a member of the Republican Party, Ms. Liebman was a member of the Democratic Party. Left to their own deserts, it is possible for members of the NLRB, bipartisanly, to proceed collegially. With regard to the current board, as it's currently composed, what they do is what they will do. But based on the January 26th report from the Associated Press, quoting Chairman Pierce, who defines the agenda of the board, it is obvious that they are contemplating supplementing already controversial election regulations and attacking the docket of administrative appeals that are before the board. It appears to be a board by his report to the press that is going to be aggressive in pursuing its agenda.
Thank you.
Mr. Gerhardt, you had a short statement to make.
I very much appreciate that, Mr. Chairman. It's very kind of you. Just a few quick points I'd like to try and make in partial response to what's been said. First is I hope we don't lose sight of the fact that I actually think an important premise we should have here is that everybody's acting in good faith. That is to say, I assume, and I actually do more than assume, that everybody here, whether I agree with them or not, is acting in good faith. I carry that same presumption with regard to Senator Lee, who was obviously very eloquent and insightful, and to all the senators, and of course the President. So that's my operating presumption. The second is that I think it's important to remember, just to sort of maybe clarify in the record, that recess appointments are perfectly appropriate to be made to independent agencies, and for that matter have been made to Article III courts and been upheld repeatedly over time. So I don't think there's any question about the constitutionality of that. And then lastly, I just want to point out that in a lot of situations, we've been hypothesizing circumstances other than those in which the President actually made these recess appointments. If we focus on the specific situation in which he made them, these pro forma sessions, in that situation, I think he's acting upon fairly strong constitutional ground. If we change the facts, we obviously might need to change our analysis, but in terms of the facts of this case, I think he's got a credible ground.
Well, we're about to go to Mr. Davis. I might only mention that in the case of NLRB, to be functioning, he only had to do 1 recess appointment. With that, we go to the gentleman from Illinois, Mr. Davis.
Thank you very much, Mr. Chairman, and I want to thank the witnesses for their patience. We keep hearing about how there's going to be a cloud, and I'm quoting, a cloud over whatever decisions the NLRB or the CFPB may make. All the same things will be true, according to some people, when rules are promulgated. We've heard that these appointees, their official acts will be void as a matter of law because, again, they didn't have the authority to act. Professor Gerhardt, you have opined that the foundations for the President's actions are sound and the appointments are not unprecedented, are reckless, and will withstand legal scrutiny. Is that correct?
That is correct, sir.
So then, is it fair to say that, in your opinion, these appointees do have authority to act because the President's appointments were lawful.
That would be the case I would make, yes.
So if the appointments were lawful, can't we dismiss all this hype talk about these nominations creating a cloud over these agencies' decisions?
Well, there, sir, I might have to actually slightly disagree with you. Here's where maybe being a law professor is a bit of a confounding thing. I actually do believe in dialogue. I actually do believe in give and take, and I think that's a robust and important part of our democratic system.
And I would certainly agree with that. But isn't it a fact that all agency decisions are judicial decisions, regardless of whether or not a recess appointment had been made, are vulnerable to being challenged in court?
You're saying, is it possible for anything to be challenged in court? The answer is yes. It could be challenged in court, but that doesn't mean it will be struck down.
In fact, would you agree that for the most major proposed regulations, judicial review of some kind is almost certain to follow?
Yes, sir. It reminds me of the scene in Shakespeare where two characters come to the ocean and one says to the other, I can summon great creatures from the deep, and the other says, yes, but will they come? So you can sue and you can litigate, but it doesn't necessarily mean it will bring it down.
In fact, two rules recently promulgated by the NLRB to reform election rules and require the posting of workers' rights are being challenged by the Chamber of Commerce and other business groups right now. So I really think it's sort of a false premise to say that recess appointments are going to create litigation when the litigation is likely to take place in any event, whether these are recessed appointees or any other kind of appointees. Individuals still have the option to ask for judicial review.
Yes, sir. I think that is quite likely. This is an era of litigation, and litigation is oftentimes politics by another means.
Thank you very much. I have no further questions, Mr. Chairman, and I yield back.
The gentleman yields back. With that, we go to the gentleman from Cleveland, Ohio, a distinguished mayor in his own right, Mr. Kucinich.
Thank you very much, Mr. Issa. It's good to be here with you. You know, I've been listening to some of the testimony from my office as well as here, and I keep hearing criticism of the President for not giving the Senate enough time to consider his nominees for the NLRB before making recess appointments. Now, Mr. Rivkin, isn't it true that President Bush made two recess appointments to the board, Mr. Cowan and Mr. Bartlett, without ever nominating either of them to the Senate at all? Is that true?
I'm not sure, Congressman Kucinich, if it's true. NLRB is not.
Okay. Well, let me assert for the record that it is true, and that Mr. Pincus.
If I may just say.
Well, I've got to move on to Mr. Pincus. So you didn't give me the answer, Mr. Pincus. Slide 10 shows we've got a slide put up here. Somebody there? Hello. Thank you very much. Okay. That slide shows President Bush's recess appointments. He made 8 recess appointments to the NLRB during his presidency. Now, did the Chamber of Commerce object to Mr. Bush's recess appointments that you know of?
I don't know, Congressman, but none of them were made in the circumstances here.
Okay, so you don't know what the Chamber did. Okay. The National Labor Relations Board, Mr. Pincus, ensures protection of workplace rights for union and non-union workers alike. Now, slide 6, go to slide 6. Thank you. As slide 6 shows, the NLRB protects the right to form or join a union, the right to bargain for wages, benefits, the right to decent working conditions, and the right to take action with coworkers to improve working conditions. Now, Mr. Pincus, you're here today representing the Chamber of Commerce, correct? And the Chamber does represent business interests, correct?
Yes.
And on behalf of those business interests the Chamber represents, it usually doesn't advocate for greater restrictions on company management, right?
I don't represent the Chamber in connection with labor issues, so I really
but you
outside my area.
But you represent the interests of company management, of CEOs of some of the most powerful companies in the country, right?
I don't with respect to any labor law issues.
But what about with respect to corporate policy?
Certainly I have clients who are individuals. I've got clients who are companies.
Well, let me ask you, hasn't the Chamber filed a lawsuit against the NLRB for its rule requiring employers to post a notice explaining employees' rights to unionize? Are you familiar with that?
I know, Congressman, that the Chamber has challenged an NLRB rule. I'm not representing it with respect to that issue. I mean, Mr. Carter is more of an expert on
the chair will stipulate that there is, in fact, an open case disputing the legitimacy of that.
I appreciate that the chair could answer the question, Mr. Pincus couldn't, but hasn't the Chamber, Mr. Pincus, filed a lawsuit against the NLRB for its rule reforming election procedures to alleviate the delays, abuse of process, and unnecessary litigation which plague the current system for workers who want to vote on whether to have a union?
I know the Chamber is one of the parties challenging that rule, yes.
And so as a representative of the Chamber of Commerce, a board without a quorum that can't enforce workers' rights is somewhat ideal, isn't it?
I don't think that a government agency that can't act is ideal. On the other hand, our constitutional system, as Senator Lee said quite eloquently, I think anticipates there are going to be these collisions that have to get worked out. When the government had to close because there was no funding, because appropriations bills hadn't been passed, I think everyone would agree that wasn't ideal either, but it got worked out.
Got worked out. But what hasn't been worked out here is the Chamber's consistent opposition to the NLRB, and frankly, the concern that I have, Mr. Chairman, is that these oppositions to the recess appointments, and what they really represent is opposition to the NLRB, because the witness didn't give us any information about what they did when President Bush made the appointments. So I thank very much the witnesses for their participation. I thank the Chair for the opportunity to be here.
I thank you. Ambassador Gray, as far as you know, all of those appointments are up in, I think, slide 10. These all occurred during mutually agreeable recess events?
Yes, sir.
So the fact is the Senate allowed for recess appointments by its very design, along with the House.
Absolutely. There's nothing illegal or unconstitutional about a recess appointment except in the context when there's no recess.
And I'd like to look at all five of you. I will take a head nod. Nobody here today, for the whole several hours, first or second panel, objected to the power of a recess appointment. Is that correct? So there's no dispute. The President has an absolute constitutional, one would say, obligation to keep the government running during recesses, and that's why the Founding Fathers gave a recess appointment authority, correct? Mr. Gerhardt, you've been very good, and I think you've been balanced in trying to answer questions, even though you somewhat disagree with some of the other panelists. You said something earlier that I focused on a little bit, and that's since the administration itself says there is litigation risk, I thought I heard you say, and maybe you want to correct that, that there wasn't because there was risk that it would be upheld. Isn't there litigation risk, and isn't that risk potentially leading for this committee to the fact that NLRB or the Consumer Financial Protection Bureau would have laws similar to the New Steel that might have to be invalidated? Isn't that a risk? Not just a risk of litigation, but a risk that their actions could leave them not valid in what they do between now and whenever the Supreme Court finally acts.
I very much appreciate the question, Mr. Chairman. I don't think the fact that the OLC memo mentioned that there's a litigation risk tells us anything about the merits of the case.
Sure. Now, and Mr. Davis, when he originally posed that, right, I don't think he knows the outcome. It might be, if it goes up and says, hey, they were in recess, then there's no risk to these appointments. There may be some risk to the law on January 23rd or December 23rd, but let's just assume that the court divines that they weren't in recess on the 23rd, they were in recess on the 24th for purposes. Then nothing happens. All we've had is a lot of litigation for a period of time. What if it doesn't happen? This committee came together to ask all of you and our first witness about what if. And I'll start with Mr. Carter, and I'll sort of go from right to left this time. What if in fact, we find that these appointments, one or more of them, would be considered to be inappropriate, and we assume it would be all of them or none of them, what is the risk to the actions of the NLRB and these individuals, 3 individuals, both parties, and obviously the lesser actions specifically of the new director?
Mr. Chairman, that's the greatest danger here is the volume of risk. The volume of risk is expansive. Unlike the situation that Congressman Davis was describing, which is, well, every bit of litigation is subject to appeal, right? I mean, so what's the difference? What we're talking about here is an agency that is acting ultra vires with the NLRB. It's not 1 or 2 of the cases that might be brought to appeal by one of the litigants. It's every case that they decide. It's every regulation that they implement. It's every official action that they take. And those affect real people with real rights who will really be hurt. 2 examples, if I may. Let's take a situation where an employer is told by the NLRB this coming year that they have illegally relocated work from one manufacturing plant to another.
You mean maybe to South Carolina?
Let's say South Carolina, sir.
Oh, wait a second. That one got sort of dropped once the union got what they wanted. Okay, go ahead. Continue.
Well, let's say West Virginia, my home state, where we really need jobs. And the National Labor Relations Board says you can't put a new plant there. Employer, everything you put into that re-engineering of that plant, all the people that you've hired and their livelihood that they've already taken out mortgages on and bought cars with, that's all gone. They don't have jobs. You don't have use of that plant. We're transferring that work back. But then
But couldn't the people of West Virginia assume that the President was inappropriate in the recess decision and just decide to ignore it? Couldn't they just ignore what the President's done since he ignored what the Senate said? I mean, isn't there a constitutional power of the House, the Senate, the Supreme Court, and maybe, just maybe, the American people? I mean, I know they're not explicitly named, except I thought they had these rights. You know, life, liberty, and the pursuit of happiness. And there's nothing make me happier, it ever made me happier than a paycheck.
Anything that this committee can do to ensure that the citizenry is free from abuse by the government, which is the purpose of the Constitution, would be extremely welcome by any citizen so affected. But it's not just companies with risk. It's not just employees.
I wasn't thinking of a company ignoring it. I was thinking of those citizens not letting themselves be laid off.
Mr. Chairman, consider the last one, and I won't trouble you anymore, but consider this hypothetical, and it's not a hypothetical. What if I'm part of a shop and my employer is abusing me and those who I work with, and I want to form a union, and I have a right to form a union, and so I file a petition with the National Labor Relations Board, and the National Labor Relations Board comes in and they hold an election, and that union is certified to be my representative, and that union begins to bargain for me. And then a federal court says that it's unconstitutional. They can't certify you. It's an ultra vires action. I decertify that election result. What happens to the labor strife when those employees who had been bargaining all of a sudden don't have a bargaining representative? Do you think they'll put a picket line up? I think in my state they would. What happens to commerce? What happens when that strike starts? And what happens to that employer and what happens to products? Real people, real rights, real ramifications, really dangerous. What these recess appointments have done to our labor relations system in this country.
Thank you. Mr. Rivkin.
Thank you, Mr. Chairman. 2 points very briefly. First of all, due respect to Professor Gerhard, I think that the fact that OLC, and Mr. Gray made this point earlier, mentions, albeit in a fairly mild language, the possibility of a litigation risk is A, unprecedented and quite probative. And second, to pick up on an excellent point made by Mr. Carter, there's a fundamental difference, quite aside from sort of a specific economic footprint. There's a fundamental difference from a constitutional perspective between challenging a specific decision and challenging the legitimacy of a whole subset of a tenure of a given agency. I think it's far more destructive, not only because of all the things that would come down, but frankly it does not inspire, especially at a time where so many Americans are questioning some of the behavior of all branches of our government, to find that a given agency or 2 agencies have been acting unconstitutionally for a couple of years is a very bad thing in terms of maintaining the confidence of the people in the government, quite aside from all the cost of businesses and commerce involved.
Thank you. Mr. Gerhardt, and in the narrow question of if it is ruled that these are not, would you like to speak to the consequences?
Sure, and I appreciate that. Assuming that that were to occur, there are a couple things. I mean, the one is, I think you still may have a mootness problem. You know, that is to say, so much has already transpired. To what extent can any of that be undone ever by a court? And then I think the second thing I would just add to all that is just to reiterate.
But in light of News Deal, they did unring the bell, didn't they?
No, I understand that,
So a small injustice they can unring, but thousands of them that you think the court wouldn't do it. Wouldn't that fly in the face of Miranda?
Well,
they unrung a lot of bells with Miranda, didn't they?
They unrung a lot of bells with that, but we're talking. So in a way, we can't have our cake and eat it too here.
But isn't the court, the Supreme Court specifically, which we expect this will get to them, aren't they bound not to weigh competitive harm, but in fact to weigh the constitutional issue? Did they have the ability to? I mean, look, Dred Scott could have been kept because it's been around for a long time, and there was a lot of harm to reversing it, wasn't there?
Well, the reversal, of course, occurred through a constitutional amendment after a bloody civil war. So that's about as consequential as.
So your assumption would be that you know, probably that's one of those examples where the court would just say, well, we're unringing the bell, but we're granting no relief to the injured.
I'm saying that I think that that is one of the justiciability problems here.
Mr. Pincus, I'm sure you concur. Just give us your short concurrence there.
I was going to say, let me start with what the courts will do. I think it's quite clear that as long as the issue is preserved by the individual, in the thousands and thousands of individuals and companies that have been harmed in their individual cases, they're all going to get relief. You know, in New Process Steel, I think it was 500 decisions that were overturned. And I don't think there's any basis, and in fact, I cite some decisions in my.
So this is sort of a classic chamber question of the chamber essentially has to find a way to form a class to make sure everybody's on board. Otherwise, their failure to object could lead them to live with the decision.
I think that there's a theoretical risk of that, but I think this issue has gotten so much attention that I don't think there's any company that is going to be subject to either an order of the NLRB or an enforcement action or other action by the Bureau that is not going to know to have a paragraph in its complaint saying, and by the way, the director or the two members were appointed unconstitutionally. I think it would be probably close to
3 members. 3 members,
yes. So I think there will be relief, and I think that's what makes the situation very different from Mr. Davis's. Sure, there are a lot of judicial review of government actions. The government wins almost all of those cases, and they're all, of course, case-specific. What we're talking about here are thousands, maybe, certainly hundreds of government decisions that will all be set aside at once, and that's obviously a big waste, especially, as I said in my testimony, when some of them are going to involve fraudsters who could have been prosecuted by the pre-appointment Bureau or by the FTC and who will now go free or have to go back to square one. There's a lot of harm that's going to happen, I think, and a lot of wasted government resources, unfortunately.
Ambassador, this may not be, the cost may not be right up your alley, but you want to take a little whack at it?
Yes, sir. Well, I did put it in my prepared testimony, which also deals with due process, which was where they didn't have a quorum. But in Buckley v. Vallejo, and not to throw a monkey wrench into this, but there were questions about the makeup of the FEC because of the appointments clause, and I'll just read you what the court said. It is also our view that the Commission's inability to exercise certain powers because of the method by which its members have been selected should not affect the validity of the Commission's administrative actions and determinations to this date. So Buckley v. Vallejo, to the extent that it's a precedent, and Andy's the former SG, that looks like it may cast some doubt on the applicability of due process.
Well, I'm not going to allow any further follow-up on this. I think for purposes of the record, we've been pretty clear. I'm going to ask one final one, and this is one that you may all weigh in on as constitutional scholars. and only in that way. Historically, the Court has held very little. They've respected directions from the Congress when it came in the form of a law. They have not ordinarily given standing, and Senator Lee said that in his testimony and in the Q&A. But in the case in which the House of Representatives has not granted the Senate the right to adjourn, does, in your opinion, the House of Representatives have a separate action, separate from law, but as a body of government constitutionally specifically given a right/obligation, do you believe that we have potentially standing?
I'll just say first, I'm skeptical, but I don't think it matters. There's going to be a challenge. There's going to be a ripe case that comes up. You will file amicus briefs, and what you say will be taken very, very seriously.
I think that you do have a standing to vindicate your constitutional authority under Section 5, Clause 4. And as much as I respect my dear friend and former boss, Mr. Gray, I think that it is essential for you to speak with your own independent voice for a simple reason that if you look at the separation of powers issues over 200+ years, an OEC analysis, the behavior of each branch at each particular point is given tremendous weight. It is your constitutional interest to vindicate. The fact that private plaintiffs may well strike down all the regulatory emanations from NLRB and CFPB does not substitute for at least trying, if you fail in motion practice, the motion to dismiss because of lack of standing, and I don't think you will. It's still worth trying to at least demonstrate that you take your constitutional authority seriously.
Mr. Carter, and Mr. Gerhardt, I'm coming to you as the last word. That's
right. I'm persuaded by both of these fine gentlemen. My only word of caution, if it's of any value at all, is I was very, very convinced by comments from the congressman regarding the inappropriate invasion of the House's jurisdiction as well as the Senate's when the chief executive sought to define what was adjournment, what was recess. That is the balance that I would encourage the House to consider, because ultimately what this is a separation of powers argument where the chief executive has plainly infringed upon the legislative branch's authority.
Mr. Pincus, you're the second last word. Briefly.
I agree with Ambassador Gray. I would add one other caution, which is I think it's in actions between the branches or their representatives that the courts are most likely to invoke the political question doctrine. And I think that's not likely to happen in the kind of lawsuit that we're talking about, where there's a private party who's the plaintiff and the House or members of the House and the Senate appear as amici.
Mr. Gerhardt, I'm thoroughly looking forward to seeing that, because on this, I don't think the question is the same as the ones that you've been asked up until now.
Right, and it will not surprise you, therefore, Mr. Chairman, that I probably agree with Ambassador Gray on this one. I think that it's not likely. I think the House would have independent standing, but that may just be a technical matter. There's no question at all that the House would be heard on that. And if I may—
What do you think about Mr. Rivkin saying, but you ought to try?
Well, you could try, but I think that what I think we see from the standing cases is that it's not likely that the court's going to recognize some independent standing on the part of the House here for the reasons I think Mr. Pincus suggests, and I think for reasons we've seen in other cases in the past. In other cases where recess appointments have been challenged, pocket veto case, for example, we don't see the House given independent standing in that circumstance.
But the executive branch often asserts independent standing.
Right. A 10-second point. We, as litigators, we all know there's enormous difference in participating as amicus and participating as a party. And even if you don't gain independent standing, I'm sure Professor Gerhardt would agree you would gain standing, piggyback standing, because it's not subject to the same constitutional analysis. It is important for you to speak and as robust of the voice. And with all due respect, filing amici briefs is not the same thing.
Well, I thank you all for your opinions. As chair, the challenge I have is the question we asked you all here for, which is the potential near irreparable harm to individuals in the execution of government. The cost of government in dollars probably is de minimis, even if it's in the millions, compared to the human lives of businesses and others around the country who will assume one thing, and if it's reversed, deal years later with a very different outcome. So it is what this committee, I think, will continue to try to evaluate. I would ask only two things, and that is, as you look back on today's statements, questions, and answers, we'll hold the record open for 5 additional days and longer if I get a request from any of you to revise it, extend, or give us any additional information you think would help us in our deliberative process. Seeing only shaking heads positive, we stand adjourned. And by the way, that's adjourned, not recess.